still alive. I'm happy to see you.
I'm still alive, my justice.
Okay. Mr. Valoi?
Please, my lord, the state has prepared its heads as requested by the court.
Right.
Just a short while ago, I inquired from the investigating officer if the notes were found. The investigating officer, however, informs me that the notes were shredded, destroyed after the statement was made, and therefore the notes are no longer available.
Fine. That is the investigating officer.
Yes.
But what does Mr. Zungu
Yes.
say?
No, I haven't spoken to him as he's under cross-examination, my lord.
Oh, yeah, correct, quite correct. I'm just going to ask Mr. Mnisi, I'm just going to ask if you heard the prosecutor says, according to the investigating officer, the notes were shredded.
Yes.
So I'm going to find out from Mr. Zungu whether the order of the court that they must go to Natal, KZN, and discover or fetch those documents, whether he did that.
I don't have an objection.
Okay, thank you. Mr. Zungu, did you go down to KZN?
My justice yeke zokusemandleni wami konke ukuthola ngenze konke okusemandleni ami ukuthola amaphupho noma lawo maphepha engade ngiwasebenzisa ngakuthola khona kwathola.
Lalela. All I'm trying to ascertain, did you go down to KZN?
My justice ngicela ungakuvezi ngoba for a security reason.
I would like not to divulge it for security reasons, my lord.
No, fine, I understand. But you did go down
Yes,
to
I did.
KZN?
Yes,
You did go to the place where you said there's a possibility that, or the probability that you'll find the notes,
yes.
right? Did you find them?
No, I didn't find them. The only thing I found is the statement, the one that I rectify on that day.
Okay, fine. No problem.
Njeke ama-notes akawatholanga yekuhambile awakuthola-ke i-statement lesi awasilungisa ngaleliya langa.
Okay. Yeah, the court at the last hearing requested that the state and the defense should prepare heads of argument regarding the exigency that which was raised by Mr. Mnisi when he started to cross-examine, that his cross-examination is impeded by the fact that his instructions are that there was a statement, a written statement, or a written affidavit signed by this accused. Am I correct, Mr. Mnisi? Consequently, the imputation is that there are two affidavits. One is written and signed by this witness, Mr. Zungu, and the other one is a typed one. Is that how I understood you?
Yes, madam.
That's it.
Yes.
So you insisted that you want the production of that statement, the written statement or the written affidavit.
Yes, madam.
Okay, fine, thanks. And this court, when Mr. Mnisi came up with that contention, initially said, look, before court there is only one affidavit which appears to be typed. But on reflection, on the assertion made by Mr. Mnisi, I thought that in the interest of justice, it would be fair and it would be in accordance with the principles of according the accused, a fair trial, that this court should investigate and interrogate the question whether in fact there are two statements under oath. There are two affidavits. One, according to the instructions of Mr. Mnisi, which is written and signed by this witness, and the other one, which was deposed to before Colonel Gunanda and signed by this witness, because that exigency impedes.
Yes. It's neither here nor there.
Okay, fine.
Yes.
But, you know, it's a question of whether, in fact, there are two affidavits or two statements. The witness says he is only aware of the fact that he composed notes from which the statement was extrapolated when he was being interviewed by Colonel Ginanda. Right. Okay, go ahead.
Indeed, my lord. In other words, mention is made of a statement, but the witness is talking of notes.
Fine.
Yes, and counsel, after court adjourned on Friday, they did listen to the recording, and this also, according to my notes, that initially mention was made of a written statement, but the witness did subsequently explain that what he really meant was that the statement was composed out of notes and that there's no written statement as such. That was my understanding of the
fine.
Explanation.
Yeah, fine. No.
Okay.
That is your understanding, but Mr.
Yes.
Mrs. instructions are that there is a written statement. Okay, fine.
Right. Now, I don't know whether in light of the fact that the notes stroke statements cannot be traced, or that the notes have been destroyed, whether it is really worth the trouble to then continue arguing the matter. But if that is the case, my lord, we will then continue to
Yes, fine.
to address the court.
Yes, please do.
Court pleases, we've prepared heads of argument in
Sorry,
this.
have you circulated
Yes,
them?
yes, I've just
Okay,
given
fine.
them copies. And the heading of our heads, my lord, is heads. Request by accused number 3, counsel for disclosure of notes used to compile a statement of State Witness Constable Siza Zungu. As I've just explained now, that following on the explanation by this witness is that what was in existence were notes and not a written statement as such.
Sure.
Now, in the introduction, my lord, we mentioned that the current witness, Constable Zungu, has finished giving his evidence in chief and has also been cross-examined by the legal representative of accused number 1 and 2, Mr. Ramosipeli. Paragraph 2, we mentioned that...
No, let's be factual.
Yes.
He was cross-examined by Mr. Ramosipili, right?
Yes.
But Mr. Mnisi did not conclude his evidence, his cross-examination.
Yes, we will get
when I intervened.
Yes, we
Okay,
will get
fine.
into that, yes.
All right.
Paragraph 2, when it was the turn of counsel for accused number 3 to cross-examine the witness, Advocate Mnisi indicated that he requests that the handwritten statement be disclosed to him. As we mentioned, this is subject to the corollary that we have just referred to. In paragraph 3, the witness has explained that his statement was compiled using notes of recordal of certain incidents in this matter. He indicated that these notes are kept at various locations where he lives, including in KwaZulu-Natal, as the court has just confirmed that with him. Paragraph 4, he mentioned further that there is an error in paragraph 5 of his statement, wherein he sets out the sequence in which he saw the accused around 2100 hours coming from outside and following each other to Gwabeni's bedroom. He says where the name of Nkani Sfisokuhle Zungu is mentioned in paragraph 5, it should be substituted with that of Mthobisi Ncube, accused number 3. In the statement, he states in paragraph 5 that, and we quote, around 9 p.m. on the very same day, I noticed Muzi Sibia, this is accused number 1, Mafika Sandiso Ntanzi, accused number 2, and Nkani, in brackets, Sifisokuhle Zungu, that is now accused number 3, walking after each other to Gwabeni's bedroom, coming from outside, close the quotation. He says that where the name of Carlos Mthobisi Ncube, accused number 3, should have been inserted instead of that of Nkani Sifekuhle Ntuli. Sorry, there's Zungu, there should be Ntuli. That is now accused number 5. And further on in that paragraph, wherein he states that, and we quote, I saw Nkani, accused number 5, giving Gwabeni a 9mm, should be substituted with the name of Carlos Mthobisi Ncube, accused number 3. He states that further that in the same paragraph, the name of Mtokosizeni Mapisa and Carlos Ncube walk into the bedroom and sat on the bed. The name of Carlos Mthobisi Ncube should be substituted with that of Nkani Ntuli. So in other words, my Lord, he's saying everywhere in that paragraph 5, where the name of accused number 5 appears, it should be substituted with that of accused number 3. In paragraph 5, we mentioned that in the matter at hand, the accused is not laying claim to any of the contents of the police dockets, but as we've just indicated, my Lord, but to notes which do not form part of the police dockets, but which were used to compile the statement of the witness. Then, my Lord, we deal with authorities. We refer to the case of State versus Rowand, 2009, volume 2, SACR 450, and is the decision of the then Witwatersrand local division, where the court dealt with the right of an accused to full access to the documents in the possession of the prosecutor or the state before the trial. In that case, my Lord, the accused contended that it appeared from the documents to which the state had given them access that there must be further documents in the state hands which might be relevant to the case or to their intended application for stay of prosecution. The novel point of law in that case was whether the accused had the right of access to information and documents in the possession of the state and pertaining to the case, but not included in the case docket. In that case, my Lord, the accused was facing charges of fraud as well as statutory counts which involve complex financial, legal, and commercial issues. And the paragraph that we want to put emphasis on is at page 451. It's paragraph D to E, where the court held that where such a document was in the possession of the state, and in here, my lord, the emphasis falls in the possession of the state, it ought to form part of the docket. And we argue, my lord, that Rowan's case is distinguishable from the current case in that the state is not in possession of the notes mentioned by the witness, nor have we seen them, my lord, nor deliberately left them out of the docket, as was the position in Rowan's case. And we also mentioned that Rowan's case is distinguishable from the present case in that, as we've just intimated, my lord, in Rowan's case, the cases relate to fraud and involve complex financial and commercial issues. We also refer to the locus classicus of State versus Shabalala, 1995, Volume 2, SSER 761, decision of the Constitutional Court, and the case of State versus Buota, 1994, Volume 4, SSER 541, decision of the then Witwatersrand Local Division. And we qualify that, my lord, that in that, or in those cases, they only dealt with witness statements contained within the docket. Then under Section D, we deal with what we perceive to be the legal position. In paragraph 9, we refer to Section 35(3) of the Constitution, which states that every accused person has got the right to a fair trial, which includes, firstly, or in the context of the current case, the right to be informed of the charge with sufficient detail to answer it. And secondly, in the context of this case, the right to adduce and challenge evidence. In paragraph 11, we mentioned that the Constitutional Court in the case of Shabalala and others versus Attorney General Transvaal and another, 1996, volume 1 of South African Law Reports at page 64, the Constitutional Court held that the defense is entitled before the trial to all statements in the police docket, except where there is a reasonable risk that disclosure of a statement will lead to divulging of state secrets, method of police investigation, the identity of informers, or could otherwise harm the interests of justice. And further held that the court must weigh up the respective interest, that the defense must set out a prima facie entitlement to access, and the state must advance justified grounds for refusal. And we refer to the relevant paragraph, page 16, paragraph 16. As a starting point, the defense is only entitled to documents contained in Part A of the docket, and my lord, that they've been furnished with, witness statements, expert reports, and documentary evidence, except insofar as this may be privileged. The defense is also entitled to copies of documents which are not in the docket, but which are in possession of the prosecutor or the state, and which form part of the state case. As we've mentioned repeatedly, my lord, that the state is not in possession of the statement stroke notes. And in paragraph C, we state the test that ought to be applied in a request of this nature. And in paragraph we state that the basic test in the present application must be whether the right to a fair trial in terms of Section 35(3) of the Constitution includes the right to have access to notes that were used in the compilation of a statement. And similarly, and borrowing from the language used in Shabalala's case, it was held that this is not a question that can be answered in the abstract, but with regard to particular circumstances of the case and in the broad context of a legal culture of accountability and transparency manifested by both the preamble to the Constitution and the Bill of Rights. This was per Justice Mohammed, the late Justice Mohammed, and referred to the relevant pages, page 26, paragraph 35 to 36, wherein he held as follows: ordinarily, an accused person should be entitled to have access at least to the statements of prosecution witnesses, but the prosecution may, in a particular case, be able to justify the denial of such access on the grounds that it is not justified for the purpose of a fair trial. We mentioned that what a fair trial may require in particular case depends on the circumstances of each case, as it was mentioned on page 26 of Shabalala. And in paragraph 14, the question in casu is whether the disclosure of this witness statement, I think that statement is missing there, is sufficient to enable the defense to prepare its own case sufficiently or to properly exercise its right to adduce and challenge evidence or to identify witness who might be able to contradict the assertion made by the state witness, or to obtain evidence which might sufficiently impact upon the credibility and motives of the state witness during cross-examination, or to focus properly on significant matters omitted by the state witness in their depositions, or to properly deal with the significant matters deposed to by such witness in one statement and not in another, or deposed to in a statement and not repeated in the evidence, or to hesitation, contradictions, and uncertainties manifest in a police statement, but overtaken by the confidence and dogmatism in viva voce evidence. This is a passage that we quote from Shabalala, page 27, paragraph 37. We mentioned in paragraph 13, my Lord, that this matter at hand is distinguishable from the Shabalala case in that we are not dealing with the request for disclosure of a statement, but disclosure of notes, recordal of events which were used to draw up a statement. And we mentioned here, my Lord, that the defense will usually not be entitled to memoranda in the docket, in the B part of the docket, and here we refer to motivated index of internal reports and memoranda contained in Part B of the case docket, and the investigation diary contained in Part C of the docket. And in the Shabalala case, the court set out the following guidelines in resolving the issue. Firstly, the court held that it is difficult to conceive of any circumstance in which the prosecution can justify withholding from the accused access to any statement or document in the police docket. And here, my Lord, the emphasis falls in the police docket, which favors the accused, or is exculpatory. And secondly, inherently there might be some element of uncertainty as to whether the disclosure of the relevant documents might or might not lead to the identification of informers or to the intimidation of witnesses or impediment of the proper administration of justice. And in light of the fact that the state hasn't seen the notes/statements, we are not in a position to advise the court as to whether there's any prospect of intimidation of witnesses or impediment of the proper administration of justice. And the court then went on to hold that if in the special circumstances of a particular case, the court needs to exercise disputed documents in order to make a proper assessment of the legitimacy of the prosecution's claim, and any insight that document might reasonably defeat the protection which the prosecution is anxious to assert, then the court will be entitled to examine such documents for this purpose without affording the accused an opportunity of any knowledge of its contents, but making proper allowance for that factor in the ultimate decision. This, my lord, was the proposal that if the notes were found, that was a proposal that the state was going to make, that that the court should first have sight of the notes and then inform the parties as to whether there's any possibility of intimidation or impediment of the proper administration of justice. However, in light of the fact that the statement/notes are not available, the matter has since now become moot. What is important, my lord, in this regard is that the court is vested with a wide discretion as to what should be done in the circumstances. And we deal briefly, my lord, with a related topic which, strictly speaking, it's not relevant in the matter, and there's the issue of the police diaries. And we mention here that the same consideration applied to the police diary as to those that apply to statements in the docket, as those diaries form part of the integral part of the witness statement. We mentioned that the state can refuse to disclose privileged information taken up in the diary, but the reasons therefore must be disclosed, and we refer to the case of Jonas versus Minister of Law and Order, 1993, Volume 2, SACR. Page 692 is the decision of the Eastern Cape at 696E to G. And we mentioned, my lord, that the police are issued with diaries or pocketbooks specifically for the purpose of documenting events which would assist them in compiling their statements at a later stage. And we mentioned here, my lord, we have seen, for instance, in the case of Warrant Officer Musia, that his pocketbook forms part of the, or it is an integral part of his statement, and as he documented certain events therein, and the extract of his pocketbook has been handed up as Exhibit C4. In Jonas' case, should be Jonas, not Johan's, Jonas' case, it was held that information recorded with the purpose of being used in the preparation for or in the prosecution of the trial and forming part of the prosecution's brief, for instance, contents of the pocketbook, form part of or form an integral part of the witness statement, and or they are a record of information intended for use in the preparation for or in the prosecution at a criminal trial, and and to form part, there should be part, my lord, to form part of the prosecutor's brief. We submit in conclusion, my lord, that the notes made by the witness stand on a different footing from a policeman's diary or packet book, and should not be subject to disclosure, but subject to the corollary, my lord, that the court should first have a judicial pick of the notes, and then inform the parties as to whether there's any possibility of intimidation or the impediment of the administration of justice. And we submit, my lord, that this witness, Constable Zungu, should be cross-examined on the basis of his statement and the explanation that he gives for any contradictions between his testimony and his statement will be subject to any credibility findings that the court will make at the end of the case. That, my lord, are our submissions.
Okay, thanks, Mr. Baloyi. Kamusipiri, Mr. Okay.
Mr. Mnisi will take up the point on behalf
Of all of you?
For me.
For you?
For me, my lord.
Okay, Mr. Ngamalo.
My daughter, I did not also prepare the heads of arguments. I was of the view that it was a matter that was going to be argued on Tuesday or Wednesday.
Oh, Tuesday, Wednesday?
Yes, that was the understanding.
I'm in court on Monday.
Yes.
Okay, Mr. Mshololo. Sorry, Miss Mshololo.
My lord, I will address the court. I did not prepare the haze, but I'll argue. I'll make my submissions, my lord.
Now?
Yes, my lord.
Make them.
No, I mean after Mnisi, my lord, because Mnisi is going to take the space first, my lord.
Oh,
and
okay.
then
Mr. Mnisi, they say you should. Yeah,
in the same
Mnisi?
breath with my colleague, I did not prepare something readable in line with what the state has done, and that is not out of contempt of the court. However, I understood the court to mean that if we can do so.
Yeah, fine.
But nonetheless, my lord, the issues here are very crisp and very succinct. The court will remember, just before I could commence with my cross-examination, I brought it to the attention of the court, my lord, that I had a conversation with the state wherein I actually requested the original copy of the statement, because the copy that we were issued with is a typed version. Then the state said no, it did not have such a handwritten statement.
Right.
I thought that the matter would then have rested at that point. However, subsequent to Mr. Zungu's testimony and him being cross-examined by Mr. Ramusipili on behalf of accused number 1 and 2, he mentioned very unequivocally that there is a statement that he wrote with his own hand. He initialed it, he initialed each and every page, he signed it.
So Mr. Zungu says there is a statement.
Yes, my lord. I'm still addressing the court.
Yeah. It's not being interpreted. Do you understand what Mr. Mnisi is saying?
Yes, I do.
Fine, okay.
Thank you, my lord. You said there is a statement that he himself wrote in his own hand. He initialed each and every page thereof. He signed it, and it was commissioned. And I then said it would really be very grateful if we were to be furnished with that original statement, my lord, that is handwritten. That is when then the whole issue started to be thrown into disarray. That's when the explanation regarding the existence of a note from which that statement that is typed was compiled from, that is how then the issue developed.
Okay.
Then accused number 3, gentleman that I'm representing, my lord, called me or drew my attention to the fact that, called me in order to draw my attention to the fact that, no, in fact, the issue of a statement, as it was testified about by Mr. Zungu, that he says he initialed each and every page thereof, that he said he signed it, that he said it was commissioned, is actually on record. It is actually on record.
Actually on record?
Yes. Then what happened, my lord, after the court had made an order that there should be some kind of an escapade to go to KwaZulu-Natal to go and look for those notes, which apparently the explanation is given that they've been shredded, they cannot be found, then ensued. But we had an opportunity, myself and my colleagues, to go and have a listen to hear what the record, insofar as Mr. Zungu's testimony on this aspect of the inquiry is concerned, my lord. I may say, my lord, without any fear of self-contradiction, that what we have been maintaining all along is confirmed by what is stated in the record. And in fact, I would have requested this court, my lord, that just to put the matter at rest, the court should, I'm going to request, but it's not an instruction, I'm going to request the court to consider actually listening himself exactly what Mr. Zungu said about the statement, my lord. We're not requesting notes. The issue of notes was never ever part of our request. We based our request on the basis of Mr. Zungu's very own testimony about the existence of the statement, my lord. Okay. And that is the position that we're still maintaining, my lord.
Okay, fine. I say fine. I hear you.
Thank you, my lord. So the submission that has been made by my colleague here with regard to the Jonas case, the Shabalala's case, and all those cases which were stated there, my lord, are distinguishable from what is happening in this particular inquiry, because it is not like we're requesting something that the state does not have. The state does have this information, however,
no.
For the sake of...
put it clearly.
Yes, my lord.
The state does have Mr. Zungu's signed statement. Is that what you're saying?
That is what I'm saying,
so
that
there must not be any misunderstanding.
Yes, and I'm basing this on what he himself said under oath.
No, I hear what he says.
Yes.
But your submission is the state does have a written statement which is commissioned and signed by Mr. Zungu. That's your submission.
That is my submission, my lord.
Baloo,
but let me qualify my submission.
Wait, you hear that?
Yes.
No, fine. Then you can
let me qualify my submission, my lord. I am not sucking this information. I am not speculating. I'm not making assumption. I am basing this statement based on what this witness has told to this court, my lord. It is on record.
No. Mr. Mnisi, you are an officer of this court.
Yes, my lord.
There's a world of difference between what you have submitted now and what you are saying. Listen to what you are saying.
I can hear myself, my lord.
Yeah, but do you understand yourself?
I do understand myself.
Okay, let me try and quote you.
Yes, my lord. Yes.
The submission is that the state has a written statement.
Yes, my lord.
Right?
Yes.
The state has a written statement.
Yes, my lord.
Now you qualify it.
Yes.
This is based on what this witness says.
Yes, my lord.
These are two different concepts.
In my understanding, my lord.
No.
Oh, okay.
Listen to this.
Yes.
These are two different concepts.
Yes, my
when
lord.
you say the state has,
yes, my lord,
it means Mr. Baloi is misleading this court.
No, that's not.
No, come on. Let's not play marbles.
No. That does not come from me, my lord.
No.
Definitely.
This is inferential reasoning.
No, I would have said,
No. Mr. Mnisi, please.
Okay, thank you, my lord.
Let's not waste time.
Yes.
You are saying the state has.
Yes, my lord.
The written statement by this witness.
Yes.
And the state has not disclosed or discovered that statement to you.
That is the reason why we're
No,
requesting
wait.
the original
And the
version.
state
Madam.
has not disclosed or discovered that statement to you, as it is obliged in terms of the Constitution and the case of Shabalala, 1995. Is that not so?
My lord, I am not saying that the state did not disclose. I am saying
Look,
we were
the state-
requesting the original version.
Mr. Mnisi.
Yes, madam.
The state is obliged. It has no choice.
Yes,
It's obliged.
yes.
Now, if the state has not disclosed that statement, written statement to you,
Yes,
as required by the law,
yes, my lord.
then it means this prosecutor, Mr. Baloyi, has not complied with the letter of the law as enunciated in the case of Shabalala. It must be so. Otherwise, Masulan Sibe is Hangomage, Selasa Matam.
Should I respond, my lord?
Yes, respond.
Thank you, my lord. My lord, it would never have been my intention to say that the state did not disclose that information. The nip and the hub of my request, my lord, was the disclosure of the original statement from which the typed version that we were handed with was prepared from.
Yes, I hear you.
Yes, my lord. And that is basically what this witness is saying. This witness is saying that original statement is there. He says, I penned this statement in my own handwriting, initialed each and every page. It was signed and it was commissioned. Now, if the court says that I am, in a broader analysis of the understanding of the court, I am suggesting that the state willfully did not disclose that statement. That is not our point of departure, my lord. When I say we, I mean myself and accused number 3, because we only requested the original version. The minute we tend to...
Where is the original version? Where is the original version?
The state
According
must
to you.
know and the witness, my lord. They are both on the side of the state.
No.
Yes. The state and the witness must know
Okay, fine.
where
I've heard
that
you. I've
original
heard you.
version
Okay, any
is.
other
But
thing,
as
sir?
far as
Any other thing?
it is still, my lord,
Yeah?
my instruction that before we commence with the the cross-examination, unless the court were to rule otherwise, we should be favored with that original version. And this is also based on the fact that already, my lord, on the typed version that the state is requesting that the defense should cross-examine this witness on, there's a conflict of interest. There are discrepancies.
What conflict of interest?
There are discrepancies in that statement.
No.
That therefore tempt us.
No, please. Don't conflate issues.
No, I'm not conflating issues.
You are. We're talking about
Yes.
a written statement.
Yes.
Is that not so? And this court hasn't seen it. And you are saying already in that statement there are conflicts. Are you understanding yourself?
I do, my lord, because the statement that I'm referring to, that I say, there is already some contradiction in the statement that has been already read on record.
No.
I partly addressed on that statement on Friday.
Mr. Mnisi, please.
Yes.
What has been read on record is a typed statement.
That's what I'm saying, my
So
lord.
what are you saying?
No, I am saying what further buttresses our quest to receive the original version of the statement, of the handwritten statement, because, my lord, it is because of the inconsistencies that we have already been able to identify in the typed version that brings us to, it tempts us, my lord.
How can you tell this court that there are inconsistencies when this court hasn't had sight of the written statement?
Or I thought, my lord, that
What?
I thought it had already been read into record.
Listen to me.
Yes, my lord.
How can you talk about inconsistencies which emanate,
Yes, my lord.
and logically so,
Yes.
from two different statements?
No. That's not what I'm saying, my lord. I am saying already in the statement that has been read on record, the typed version, on that statement itself, already there are inconsistencies. So that is tempting us to further believe that if we're to be furnished with the handwritten statement, then the cork is going to crumble, my lord.
What?
The cork is going to crumble. I think my colleague used the word the other day that
Are you finished?
I would therefore request, my lord, that the court grants us the indulgence and instruct the state to give us, as per this witness's testimony, the original, handwritten version of the statement.
This court.
That would be my submission, my lord.
Listen.
Yes.
This court is not going to interrogate this witness about that this witness should give this court a typed statement, a written statement.
Yes, my lord.
Because your submission is that the state is in possession of this witness's written statement. That's your submission.
Finally, my lord, and with due respect, I would humbly request, as per my instructions, that to lay this matter at rest, that the court should also consider, I'm requesting the court to also consider listening at what this witness said about that statement.
No. Fine.
Thank you, my lord.
I hear you.
Thank you.
Ms. Mishola?
As the court pleases, my lord. My lord, to begin with my address regarding the issue at hand, my lord, I will ask that we play the record. We have asked the registrar to zoom in where exactly.
Listen to me. I believe what you heard, and I accept it, that this witness said he made a written statement. Fine.
Yes, ma'am.
I accept that.
Yes, ma'am. Then the next question, we have not been given an explanation by the state, my lord, regarding the whereabouts of the statement that the witness has referred to.
Has written.
A written statement.
Written statement. Fine.
Yes,
thank
because
you.
the witness, my lord, has referred to a written statement,
Right.
which has not been submitted, my lord, to the defense.
Okay, fine. I hear you.
And my lord, my submission is that it is crucial that that statement, because the witness has confirmed under oath that he did make it, that statement should be produced in order to verify, my lord, the truthfulness.
Statement should be produced by whom?
By the state, because the witness belongs to the state, my lord.
This is on the assumption that this witness has given the state the written statement.
My lord, I don't think he would have made, I agree, my lord, I don't think he would have made the statement for someone else or for any other intended purposes.
Okay, fine.
Yes, my lord, whether it was made with the investigating officer or by himself, but it should have landed to the state, my
Okay,
lord.
fine.
And now, my lord, we are faced with a typed version on which the witness has testified with. Therefore, the defense is asking for the original statement which the witness has referred to.
Okay, fine.
And has not been submitted to the defense in order to verify truthfulness, the discrepancies, omissions, and everything, my lord.
Okay, fine.
Even the type statement, my lord, will recall that it was also produced during the trial. It was not produced.
That's not true, man. The type statement was disclosed. Hello, Mr. Baloi, wasn't it disclosed with the docket?
No.
Well, the statement was only taken down, I think on
the 31st of May.
Yes.
Of July, you said.
Yeah, I think it's
because this witness was, for some reason,
31st of May. Yes, 31st
Hello?
It was taken down on the 31st of May.
That's it.
Yes.
Unless you say Mr. Baloi is not telling this court the truth. This statement, according to Mr. Baloi, was taken on the 31st of May, the typed one. Is that not so?
I think, my lord, Mr. Baloi has answered to say this statement was not disclosed to the defense before the trial started.
Fine.
It was disclosed last week.
Fine.
Yes, my lord. Which is causing prejudice on the side of the state, because what we are asking now, my lord, we're supposed to have requested it, or we're supposed to have discussed it with the state before the trial started. the original statement of the type version, my lord.
Yeah, but Mr. Baloyi says there are special circumstances here. This witness was threatened with death, and he was supposed to have made the statement then, and because he was threatened with death, and I emphasize it, he was taken under the witness protection program. And Mr. Baloyi says the reason why, for instance, his name does not appear in the list of witnesses on the charge sheet, it was because they did not want to disclose that he was going to give evidence because he's threatened with death. And Mr. Baloyi says, as a result of security reasons, this statement was only taken on the 31st of May, is it? Mr. Baloyi?
Yes, it was taken down on 31st of May.
That's the background, please.
My lord, my issue is not there regarding the fears and the protection and the safety of the witness, my lord. We understand everything. But my point is, my lord, at the time when this statement was disclosed to the defense, it ought to have been accompanied by the original statement, which the witness has referred to. But that was not done. But it appeared during trial, my lord, that the witness is still referring to that statement which he says he made.
Okay, fine.
Then my
So according to the defense, there are two statements.
there are two statements.
Fine.
Yes.
That's
yes.
basically what you're saying.
Yes, yes.
Right, fine.
And we all understand, my lord, we all have been prosecutors. We know that if there is a handwriting statement and there is a type one, you attach both statements, my lord. We know that that's common cause. And in this case, it did not happen, my lord. And all we are asking right now, if the state is not in possession of that statement, they ought just have to tell us that, no, we don't have that statement, which the witness referred to. And
But
then
Mr.
we can
sorry,
be able
but,
to...
But Mr. Baloyi has said that. Mr. Baloyi, haven't you said that the state is not in possession of a written statement by this witness?
Indeed, my lord, that's
Yeah,
what we said, and
That's what he says. He said it on Friday.
My lord, I missed that when the state made the admissions, because I had the state still referring to the notes, my lord.
Yes, the state refers to
yes. I am not
It's
referring...
not the state that refers to the note as I'm sitting here. It's this witness which refers to the notes. Mr. Baloyi, is the state referring to the notes?
Well, we're referring to what this witness, the explanation of the witness.
What does he say?
We're referring to the fact that the witness says all that he had were notes that he kept, and from which the statement that was read into the record was compiled.
And the state
and those notes.
Does the state have those notes?
No, as I mentioned this morning, that the information that we received this morning is that those notes.
No, but that's why this court ordered that those notes or statements,
yes,
this witness must go to KZN
yes,
to fetch them. Because I understood to say the state doesn't have the statement, written statement,
yes,
and the state doesn't have the notes.
indeed.
That's why this court, in interrogating whether in fact there are two statements, requested this witness to travel to Natal despite the fact that he's under threat of being murdered,
Yes,
and bring the notes to this court. That's why I made that order.
yes.
I wouldn't have made that order. Okay, fine. Yes, Mr. Msholo.
And then thank you, my lord, for taking that point further, because we need clarity on whether, what is it that is not available, because weight, my lord, is not the same. The witness has referred to the statement under oath. And if the statement is not available, it must be stated clearly on the record that the statement was made, it is not available to be produced to the defense.
Right.
And then if, my lord, the state case is that notes were made, but then they are not available to be produced to the defense, then it's something else, my lord, because the weight that these two statements or these two documents do not have the same weight.
Evidential value.
Yes,
Yes.
evidential value, my lord.
Right, okay, thank you. Any other thing?
Yes, my lord. And therefore, my lord, if the statement is not available, And the submissions made by the state, my lord, especially, can I proceed to?
Aye, the whole day. I've got 2 years to hear you.
Okay, thank you. Thank you, my lord. Especially the submissions made by the state, my lord, which refers to paragraph 3, 4, and 5. I'll summarize them, my lord. I won't refer to them as they are. Referring to the contradictions or changes that are now being made in respect of accused number 5. Had accused number 5 been privy with the original statement that was made by the witness, would have been able to look at these discrepancies on his side, my lord, referring to the statements and the type statement, my lord, and also together with the viva voce evidence of the witness.
Okay, fine, I agree. That logically, that should be so.
Yes.
Okay.
As a result, my lord, the defense for the accused number 5 is prejudiced by the non-disclosure of the original statement, which the witness is making correction of as being referred to in paragraph 4, 5, and 6.
And this non-disclosure is by the state.
It's by the state.
Right.
Yes.
Okay.
Yes.
Not the witness.
Yes, it knows by the state.
That's it. Fine.
Yes,
Fine.
yes.
Okay. Any other thing?
It's by the state, my lord. And also the further submissions made by the state, my lord, in their heads of arguments referring to part B, privilege to part B, and the test to be applied. It's totally different to the case that we are dealing with right now, my lord, because here we are dealing with the interest of justice, that if it is true what the witness is referring to, then the original statement ought to have been produced to the defense. It is in the interest of justice that we know as to when the statement referred to was taken and what was contained, what was the content of that original statement, which has not been disclosed. Okay. And exactly on top of that, my lord, part B refers to the memorandums and other conversations between the police and investigating. We're not asking that. We're not demanding that. We're demanding the statement which forms part of a clip, which the defense is entitled to it. No reference to part B and C. That is not our submissions, my lord. And also, my lord, regarding the prejudice that the defense is suffering right now, is that of having to conduct your trial or having to conduct your defense when the matter is being tried. This statement, my lord, contains...
How do you know?
Sorry, my lord?
How do you know?
No, my lord, I'm still addressing...
Yes,
why,
how do you know? This statement.
Why I'm saying that. This statement, I'm referring to the type 1.
Oh, the type statement, yes. not the written statement. Okay.
Yes, yes, my lord. I'm referring to the type 1. I want to address his lordship regarding the prejudice. Because...
No, you know what? You're putting the cart before the wagon, or the horses before the cart and the wagon. We are here conducting an inquiry whether there is a written statement. That's what this case is, this inquiry is about. I've given you the leeway to compare what is in this written statement and what is supposed to be in the, what is in the type statement as opposed to what should be in the written statement. You can't do that. Logically you can't do that because we only have one statement in court at the moment. Is that not so?
One submission, my
yes,
lord. Just one. My lord, my submission is that accused number 5 will suffer prejudice if he continues cross-examination without having the original statement of this statement. Yes,
you are correct. That's why this court went out of his way to make an order that this witness should go and fetch all those statements or communications or notes, because Mr. Baloyi says he does not have a written statement made by this witness. And I'm aware of the prejudice. That's why this court in evening the playing fields, made that order. Any other judge maybe wouldn't have done that.
Thank you, Mario, and we really appreciate that.
Yes, of course.
Yes. Those are my submissions.
Right. Now, I don't want to have a look. Did you bring any other thing from Natal, KZN, which is handwritten?
KZN okubhaliwe ngesandla.
Akukho, my justice.
No, nothing, my lord.
You didn't get anything?
Akukho okutholile nje.
Akukho, Nkosi.
Nothing, my lord.
Nothing. Okay, fine. Now, there is evidence, and I'm quoting my learned colleagues here, that you say you have made a written statement.
Inkantolo ithi ke kunofakazi noma kukhona ufakazi okushiwo ke abameli lapha ukuthi ubufakazi bakho kuvike endlulile
Uthe sit down. Yes.
Uthe uma ukhuluma la inkantolo wathi kune statement owasibhala wena ngesandla sakho bathi abameli yiloko okushilo wena ngevike endlule.
My justice, into bengikhuluma ngayo mangithi kunezinto ngiyibhale ngesandla kufana nakho ngalo statement esityipiwe ngiyabhala njengoba bengilungisa kulo ma mistake into engikhuluma ngazo mhlawumbe ngangibhala i-date mhlawumbe ngangibhale ku-newspaper or kwi-slip sasethilini or low notice engiyithole ukuthi kune-information
asibambe kancane nje. What I was referring to, my lord, the witness is referring to this typed version where there are some corrections made on it. That I was referring where I would pick up that there is something, I would then correct that. Whether I was writing on a newspaper, I was writing on a receipt or a slip, but that is what I was referring to, my lord, when I said that I had wrote down. There are certain things that I wrote down. Yebo?
And my justice, angaze ngenze statement koyi-1 until the 31st. And that's why ukuthi mayithune statement angisazi usithatha. Akekho noyi-1 ngeke ngamenzela statement.
There's not a single person that I made a statement to except the statement that I made on the 31st. Hence then I'm surprised when he says that he's got a statement which I don't know where he or she took it from. But I've never made a statement except for the one of the 31st.
Right? Continuing this inquiry, do you know what is a statement?
Statement uyazi ukuthi yini?
Yebo ngiyazi.
Yes, I do, my lord.
Do you know what is an affidavit?
Statement esifungelwe affidavit uyazi ukuthi yini?
Yebo ngiyazi.
Yes, I do, my lord.
Now, before the 31st of May this year, were you ever called by the investigating officer or any other police official or officer to make a statement regarding this issue? To make a statement.
Ngaphambi kwe-31 ekaMeyi kuwona lo nyaka ngaba ukhona yini iphoyisa noma ke umphenyi ke umseshi wecala elake lakubiza ngaphambi kwe-31st sikaMeyi la elathatha khona ke istatement kuwena mayela nalo daba lolu?
Akekho ngangamnikeza, my justice.
I gave a statement to no one, my lord.
Did you ever swear and take an oath to a statement which you made, which oath paraphrases, I acknowledge that the contents of this statement or affidavit are true and correct, and you signed it? An oath before a police officer or a commissioner of oaths or a magistrate. Have you ever done that, sir?
Ingabe khona la khona ke owafunga khona ke lokho okubekwayo lapha ezantsi. I know and understand this. Ngiyakufungela ukuthi lokho okubhalelana kuyiqiniso noma kungaphambi komanje khona la owenza statement kufungela khona.
Akekho, my justice.
None, my lord.
As a policeman of, you said 12 years experience.
12, yes, correct.
Have you ever taken a statement from a person?
Wena ngokwakho
sikhona
statement esoke wasithatha komunye umuntu police station?
Yebo go.
Yes, my lord.
And after taking that statement, did you administer the oath to that person to swear to the truth and veracity that he acknowledges and understands the contents of the very statement which he has or she has given to you, and that she signs it and you append your signature as a police officer?
Yes, I've done that, my lord.
So you know what a statement is.
My justice, ngayi Friday ngathi akekho ngamnikeza statement sami. I was willing ukuthi statement sami ngisenze ecourt ngoba bengazi ukuthi ozongithatha statement usisaphi futhi uzosenza.
Okay, sibambe lapho. I did say on Friday, my lord, that I gave my statement to no one because I didn't know as to the person that I was going to depose a statement to. Where is that person going to take my statement and do what with my statement?
What are those documents, sir?
Yini le uphethe?
It's on the statement sami ngasenza bangenzele icopy yazo.
They made this is the statement, my lord. It's the typed one.
Can
They
you
made
give
a
it
copy
to
for me.
No, can you give it to Mr. Baloyi and all the defense attorneys, and then me as the last person. You've made notes on that statement.
Unama notes owenzile lapha yena ne?
Ngenzile ya la bengangicorrecta.
Yeah, fine.
Where I was
but I'm
correcting,
saying-
my lord.
Take the permits, eh? Order. Yeah, the court has in its possession the type statement by Mr. Zungu, which statement was elicited through the integrities of Mr. Ramosipidi. And I can see that there are markings, corrections, annotations in this document. Okay. Okay. This is the judgment regarding the inquiry into whether there is a second statement which is written as alleged by Mr. Mnisi through his client, accused number 3. It gives Mr. Mnisi instructions that there is a written statement signed by this accused. Is that accused number 3 or 2 or what? 3 or 4?
I'm representing accused number 3.
Yes, fine.
It is not him who says that.
Hello?
It is the record, my lord. It
No,
is
no,
not
no,
him, it's
please,
the record.
Mr. Mnisi, just sit down.
Thank you, ma'am.
You told me you had instructions from your client that he knows that this witness made and signed a written statement. That's the judgment I'm busy with now. Mr. Mnisi, please.
Yes, it is the court.
Yes. He said you got instructions. This court doesn't know where the third accused had sight of the statement, because this is not disclosed by Mr. Mnisi because that's privileged information, and this court doesn't have to know that. But I take the word of an officer of this court, Mr. Mnisi, that he has instructions that his client is aware that there exists a written statement signed by this Mr. Zungu. Okay. The assessment of the evidential value of the notes, for instance, which Mr. Zungu says he made, regarding the alleged notes which he says he wrote, and from which he says the statement which was typed was extrapolated therefrom. It is the function of this court to ascertain the veracity of that assertion. This court is obliged if the defense raises the possibility of the existence of an affidavit, meaning the statement which is signed by this accused and which is allegedly handwritten and which is supposedly, as argued by the defense, exists simultaneously and contemporaneously with the typed statement of this very accused. This statement was deposed to before Colonel Ginanda and typed by a certain Miss Mokgoatlheng. Sorry, is it, who was typing it, Miss?
Miss Mokgoatlheng.
Yes, fine. Which was allegedly typed by Miss Mokgoatlheng. And this statement has been disclosed by the prosecution, represented by Mr. Baloyi. And according to the defense, there's another statement which exists, which is handwritten, which has not been disclosed and which has not been furnished to the defense. This is a very serious imputation of mendacity by the defense against Mr. Baloyi, who is an officer of this court. To put it in plain language, Mr. Baloyi is being accused of harboring a statement which should have been disclosed to this court, which is a very serious infringement if that could happen. He could be struck off the roll of advocates by failing to disclose information which this court is entitled to and the defense are entitled to arrive at a just and reasonable and justifiable conclusion of this trial. And this imputation of mendacity to Mr. Baloyi by the defense is contrary to the prescripts of the Criminal Procedure Act and also contrary to the prescripts and demands of the oath Mr. Baloyi took to advance the interests of justice by obeying the prescripts of the Constitution and the law, namely the criminal law and criminal procedure of this country. Since the judgment of State of Shabalala and others versus Attorney General of the Transvaal and another 1995-12, 1593 Constitutional Court regarding the defense's qualified right to copies of the statement in the police docket, the defense is entitled to be furnished with same. The court does not have, this court does not have the legal right to peruse the docket, but the court has to interrogate the defense's assertion of the alleged existence of a handwritten affidavit as alleged by the defense, because a prosecutor's sacrosanct duty is that he is obliged in terms of the law to disclose every document which the state intends using in attempting to prove his case beyond a reasonable doubt. That every document of that nature should be disclosed to the defense. And just to go back to history, in R versus Stein, 1954, 1 SA 324 AD, this observation by Judge Nicholas, he states that that decision of the AD has eliminated the hunting ground which has been opened by accused persons by the decision of R versus H, 1952, 4 SA 344T. In that case, it was held that there was no privilege which entitles a witness for the Crown in a criminal case to refuse to produce the statements of other witnesses when called upon to do so. In Stein's case, however, the appellate division has held that there is a class of privilege not specifically referred to in the decided cases and textbooks which protects and the such statements from disclosure. After Chabalala, that legal precept was eventually enunciated to be unconstitutional. Consequently, every prosecutor in this country knows that he has to disclose the documents on which a case of the state is based on. And I don't believe that Mr. Baloyi can risk the entire career he has built up over years as a senior advocate. I don't know what he would gain, because it is not a duty of a prosecutor, he is not an instructed counsel, to defend or act as an attorney or advocate of a witness in a case. The duty of a prosecutor is to present the case of the prosecution to the court for it to adjudicate and consider. It is a truism which is trite in our law that a prosecutor does not have the sacrosanct duty of pursuing a conviction at all costs. No, that's not his duty. The prosecutor's duty is to present evidence to court. It is not his duty to seek a conviction. If any prosecutor in South Africa seeks a conviction, then he doesn't know his duties as a prosecutor. The prosecutor presents evidence before this court. And even if there is evidence which contradicts the veracity and authenticity of the state case, the prosecutor is obliged to bring that evidence to the court. Consequently, for instance, a witness makes a statement and deviates from the statement, it is the duty of the prosecutor to bring it to the attention of the court that this witness has deviated from the statement which he has made. And I don't mention the deviation which is induced by intimidation, as we know happened in this court. So the duty of a prosecutor is to assist the court in the ascertainment of the truth. See in this regard State versus N, 1988, 3, South African Law Reports 450, it's an AD case, where for a variety of reasons it is stated that the prosecutor may have written notes of a witness but did not disclose them in this particular case, which is at all faults with this one. Because the prosecutor thought that these notes were not important. And because of this error of judgment, that error of judgment of a prosecutor not disclosing the notes which the prosecutor had access to after being given those notes by a witness. But in this case, this witness doesn't say he gave the prosecutor notes. But in this case, in 1988-3, S versus N, the prosecutor was pertinently given notes, handed notes by a witness. But the prosecutor did not disclose or discover those notes to the defense because he thought they were not important for the case. The appellate division, SCA, held that amounted to the breach of the prosecutorial general duty because he had to disclose those notes. See also in this regard S versus Charlie. It's a 1991 2 SA, particularly at page 52. It's an EC, Eastern Cape decision, regarding the important prosecutorial role prosecutors play in the criminal procedure. Sorry, I wrote this thing last night. Yeah. In the textbook by Himstra, Criminal Procedure, this is the 5th edition, printed in May 2018. He states that making the police docket available to the defense after the initial uncertainty regarding the status of the police docket, the Constitutional Court in Shabalala and others versus the Attorney General of the Transvaal and another set out the position regarding the defense's right to the statements in the police docket. It amounts to this: the defense is entitled before the trial, but not for the purposes of a bail application, to all the statements in the police docket, except those in respect of which the state on specific grounds claims privilege, where there is a reasonable risk that disclosure of a statement will lead to the divulging of state secrets, methods of police investigations, the identity of informers, or information between legal representatives and clients, or could lead to intimidation of witnesses in the weighing up the needs of the accused against the interests of the state. And absolute privilege cannot exist in terms of the Constitution. See in this regard S versus Makiti, 1997, 1, all South African reports, law reports, 291B. The court must weigh up the respective interests, the defense must set out a prima facie entitlement to access, and the state must advance justifiable grounds of refusal. In this regard, the case of Pinatiau versus the state and others, 217-1 SACR 354 Eastern Cape. This is not the case in this, as alluded to in these reports. Mr. Baloi, who is an officer of this court, tells this court and has told his contemporary colleagues that he does not have a written statement by this witness, Mr. Zungu. Mr. Zungu, I agree, may have stated that he has made a written statement, but today, now, I have asked Mr. Zungu pertinently, who is a police officer, he's not a lay person, whether he has made a written statement which he has deposed to under oath and signed, and he says none. The only statement he has deposed to is a statement that was made on the 31st of May 2023 before Colonel Binanda, and it was typed by Mr. Setlogelo. There is a fundamental difference between a statement, a police statement, and a witness statement. The imputation by the defense is that the state, as the Dominus Litus, has refused to hand in and disclose the written statement. Mr. Baloi, on behalf of the state, says that is not so. See in this regard the case of State versus Sehule, 2015-2 SACR 196. It's an SCA case. And see also in this regard the case of S versus Gandu, 1981, 1 SA 997 TK at 998, paragraph E to G. And I'm quoting this case in this regard that formerly, before blacks were appointed to the bench, white South African judges relied exclusively on the interpretation of an interpreter, and I'm not attacking you in any manner. So in this court, they say the court can use its own linguistic knowledge as part of a witness's evidence and demeanor, even when an interpreter is used. And this is supported as long as the presiding officer therein clarifies with the witness on record via the interpreter that he intends using such knowledge, on what forms the basis and to what extent such knowledge is used. And the court has the duty, for instance, to form the view if the interpretation does not accord to the court's understanding, because the court understands that language, like this judge, who is a black man, not an Englishman. I listen, and when the interpretation is not apt, I intervene. And C lawyers say this judge is interfering. But there's legal precedence in our courts that a judge who understands the language of the witness, if there's an interpretation lacuna, he can fill it up. Because the court understands the words recorded in the original language. But the accused must be informed that the court understands the words and confirms through the interpreter, and must also be recorded in the English of recordal, because we don't write judgments in Tsonga or Sotho or Zulu. We write them in English. See in this regard S versus Ndala, 1996-3, All South African Reports, 65, Cape. And just briefly, some people may just think I have just cross-examined this witness about whether in fact he made a written statement or not. This is from the inherent rights this court has to attach value, evidential value to the proceedings or statements made by the accused in this court. And this court is entitled, in terms of legal precedence, to direct the proceedings of this court so that justice is done and it is seen to be done. That is why this court, for instance, made the remarks that some of the accused here intimidated a witness. See in this regard S versus Ngabinde, 1989-2, SA 421, Natal. Consequently then, that is why when Mr. Mnisi was beginning with his cross-examination, I had to intervene, because Mr. Mnisi was insistent that there is a document, a statement, a handwritten statement which has not been disclosed to him, that consequently his client will suffer prejudice. The same sentiment is being alluded to by Ms. Mshololo and with the concurrence of his legal colleagues. I also am of that view that if Mr. Baloyi, and I don't think he did that, refused or hid a written statement which is signed by this witness, which witness says he did not sign any written statement. If Mr. Baloyi, for instance, at the risk of his career, would not disclose the written statement, and by the way, Mr. Mnisi's instructions don't include the assertion that I saw this statement, written statement, which was signed by Mr. Zungu at such and such a place. No. It's a carousel assertion that this witness has signed a written statement. There's no further particularity to say, I saw it. I was in so-and-so's office. I was being interrogated, and I was shown this written statement by the arresting officer or the investigating officer, and I saw this written statement signed by Mr. Zungu, and I was referred to its contents in the interview by Colonel so-and-so or Police Sergeant so-and-so. No, it's a blank statement. There is a written statement signed by the accused. No further particularity. So, the defense's cross-examination, which was supposed to be predicated on the alleged written affidavit or statement, that statement was not before court, and this court, that statement must be brought to this court by Mr. Zungu, or the notes must be brought to this court, because Mr. Baloi, who is an officer of this court, says, I don't have that statement. I'm not even aware of it. So, as a consequence, the court had to intervene in the interest of justice to investigate and inquire as to whether there was indeed a written affidavit or statement which was not disclosed and was not presented in court as an evidential document, and neither was there any notes written by this witness. Notes don't exist. Mr. Baloi tells me that the investigation, meaning the investigating officer and his colleagues, say those notes were shredded. See in this regard, S versus Piri, 1973, 3, 538, up to 541A. This is an SCA decision. Which regards the allegation about unproven documents which the witness also cannot prove. The same thing here. Mr. Mnisi, together with his client, accused number 3, they cannot prove the existence of this document. See also the case of Howard and Decker, the Vetkoppen Agencies versus Four-Way Estates, Pty Ltd versus De Souza, 1971-3, South African Law Reports 937, Transvaal, at 940 E to H. Consequently, this court is also aware that if there is no written statement upon which Mr. Mnisi has to base his cross-examination, this court will obviously hold that that evidence may not be introduced under the cloak of cross-examination. See, in this regard, State versus Nkwanyama, 1978-3, SA 404, it's a Natal case, and also see State versus Hepworth, 1928, because the imputation of mendacity by the defense that the witness has made a previous handwritten statement, affidavit, has not been shown, has not been proved. And the legal principle is that a trial is not a scientific experiment where certain reactions lead to exact results. It is a fallible process which forms or attempts to form a view with reasonable confidence and findings. And the court has to weigh this method because it invokes and enjoins the court to weigh the relative merits of different methods to test the reliability of the factual fundamentals. One is such a method is to weigh the relative merits of different views of fact against each other by bringing them into the confrontation with each other. Phipson, in his seminal book on evidence, the 7th edition, 1930, at page 460, which was quoted with approval in the following cases: R versus M, 1946 AD, 1023 at 1028, and S versus Van As, 1991 2, SACR 74, Witwatersrand, at 108, page 108, paragraph C to H. These do not constitute principles cast in stone. So, consequently, where a witness's credibility and honesty, like this witness's credibility and honesty, and this is not evaluating his evidence in the trial, please don't misunderstand me. It's concerning the inquiry which this court has conducted regarding the existence or non-existence of a written statement. Now, the law says a witness's credibility regarding this exigency, if and honesty, if it is assailed. Elementary fairness requires that the witness should be given an opportunity to answer to the intended accusation, namely that the deposed handwritten affidavit concerning this matter does not exist. See in this regard the case of the President of the Republic of South Africa versus others, that is versus the South African Rugby Football Union and others. This is a case where our President Nelson Mandela was taken to task by some judge about a commission of sports instituted by the late Steve Tshwete. This is a 1999-10 case, BCLR 1059, Constitutional Court, 2001 SA, Constitutional Court, at paragraph 61 to 63. And also see in this regard State versus Buzak, 2003 SA 381 SCA, on pages 51 to 54. Where it was remarked in that context that a criminal case or criminal cases are not conducted with trickery and traps. The presiding officer in a criminal case is not simply an umpire, but controls the proceedings and has to evaluate the evidence to make a final decision. Okay. And this, of course, is to avoid the trifling away of precious court time. And last but not least, is to see that justice is done. In the case of R versus S, 1958 3 SA 667 Natal, the court is admonished not to allow unnecessary diversions where there is no concrete evidence of the existence of an alluded to document. And consequently, the court may, in interrogating such a discourse or diversion, at any stage, intervene for the elucidation regarding that exigency. See, for instance, S versus Raoul, 1982, 1 SA 828. It's an appeal court decision. And for instance, this court believes that it has complied with the guidelines as set out by the AD that the presiding officer should be aware of and should not transgress. 1, the court must not conduct its questioning in an impartial way, so that its impartiality can be doubted. The court must not take part in the case to such an extent, it mustn't intervene to such an extent that the court obscures the point in issue. See in this regard also State versus De Villiers, 1984, 1 SA 519 at 543 to 548. And also see in this regard S versus Musianyani, 1998, 1 SACR 583 at 599 J, sorry, at 596 J to 597 J. And also see in this regard R versus Rossing, 1956 4 SA 509 A. And also see in this regard S versus Mokgoatlheng, 1967 4 SA at 506A up to 568H. And also see the case of Van Zyl, 1989 at versus the magistrate. And also see the case of S. Chabela at 29G to 30E. And also see the case of Dolingjebo, 2016 1 SACR 329 SCA at paragraph 25 to paragraph 26. And the court has also had recourse to section 166 of the Criminal Procedure Act and also 167 of the Criminal Procedure Act. And consequently, this court was careful not to cross-examine this witness because the court is enjoined to remain impartial, and that this should be evident from the nature and scope of the examination, that the presiding officer should not enter the arena because a judicial officer should not only be impartial, but he has to be seen to be impartial. And the perception through the conduct of the court should not be created that a presiding officer takes over the role of the prosecutor, but the right of the presiding officer to question any accused in clarification or to question a witness in clarification is manifestly limited to elucidation or clarification of the evidence presented. And the court must bear in mind that as an umpire, it is obliged to see that justice is done, and it must bear in mind the bona fide attempts to see that justice is done, and must be perceived as impartial. For that reason, a careful balance must be maintained between interference and detachment. See in this regard, S versus Gerber, 1997 to SACR 601 SCA at 607 A to C. See also in this regard, S versus Muilwa, 1997, all South African Law Reports 351 NC, 1997, also 1 SICR 188 at, it's a Natal case at 192 to A to F, and also see the State versus Van der Berg, 1995 for BCLR 479. Which is a Namibian case, 1996, SACR 19, from page 64F to, from F to I. So, the court has utilized its discretion to decide whether certain evidence is essential or not, and in the exercise of its discretion, which cannot be interfered with, if it is exercised judiciously, this court finds that no written statement exists. Okay.
Udaba la bekhulunywa ngalo ilolu alishilo uma eqala ke kwiviki eliphelile ubaba Mnisi ukuthi ke uthe uma ulalela wena accused number 3 kanye naye ke nathola ukuthi ufakazi uthe kune statement awayesenzile. Ithi inkantolo yingakho ke isize yafika ke siyasinqumo sokuthi kwiviki elindlule ufakazi ahambe ukuthi aye eKZN uyobhekwa ke lawo ma notes noma lokho nje okwabhalwa phansi. Uma sebuya ke namhlanje uthi cha akuna statement engasibhala mina kanye ke nama notes la ebekhulunywa ngawo kutholakele ukuthi awekho. Lana phambi kwakhe unalesi statement ekuyisona lesi ebesilana vele ekubhalwe kusona athi yiko lokho bekhuluma ngako ukuthi la bebona khona ukuthi kunephutha ubese yalungisa khona, kodwa hayi ukuthi kune statement awasenza ngaphandle kwalesi sange i31 zika May kuona lonyaka ka 2013 asikho esinye asitholakala noma no hayi ukuthi asitholakala asikho ama notes la angatholakala. Uma inkantolo isilalele inhlangothi zonke ke umshushisi abameli isifikelela ke manje kwesinqumo esithi asikho istatement nanjengoba ufakazi eshilo esikutholakala ukuthi ufakazi wasenza ngaphandle kwalesi esathi uma ebhala phansi enza lawo ma notes base bona ke betype lokhu akushoyo noma lokhu ayekubhale kuma notes. Ngaphandle kwalesi inkantolo ithola ukuthi asikho esingesinye istatement, yilesi kuphela istatement sakhe awasenza lesi asenze kulonyaka nge31 zika May 2013 phambi kwakhe uKenneth Gininda.
Sorry, what time is it, Mr.?
Almost 12 o'clock.
Oh, that's all. Okay. Mr. Mnisi, you can commence your cross-examination from the start.
Is it please the court, my
Okay.
lord? On that point, my lord, Mr. Ramusipilo on behalf of accused number 1 and 2, something that he wanted to address the court on,
Okay,
my lord,
fine,
before
no
I
problem.
start with my cross-examination.
Problem?
As the court wishes, my lord, I'm indebted. My lord, part of the reason why I did not prepare heads of argument in this argument and inquiry is that I was instructed by accused number 1 and 2 to travel over the weekend to the northwest to consult with their relatives. They gave me numbers in order for us to further pursue the evidence being led by Mr. Zungu. In that respect, my Lord, I beg to reopen my cross-examination before Mr. Mnisi proceeds.
No problem.
As the court pleases, my Lord.
No problem. Mr. Baloi, any objection?
No objection.
No objection.
I'm sorry, my Lord. In fact, I did inform Mr. Baloi as well in the morning when I left.
ukuthi ebeceliweke ukuthi njengoba kumele u1 and 2 ukuthi ahambe ke ayokhulumisana nabomndeni eNorthwest manje ke useyacela ukuthi aphinde abuzeke lo fakazi kumile nalapho ebeyobabona eNorthwest.
Sir, I'm going to deal with your current statement, the 31st of May statement, and I want to deal with it point by point as you went through it, because I've received instructions pertaining to most of your testimony viva voce and in that statement.
Ngizokubuza ke mayelana nestatement sakho ke istatement sakho ngokulandelana kanye naloku okushilo la enkantolo.
Now, on the 26th of October 2014, what was the special occasion for Gwabini to call you to come to Fostora's hostel where he resided?
Kwakuyini ke ekhethekile noma kwakuyini ke occasion ke 26 ka October 2014 le eyenza ke ukuthi Gwabini akubize ukuthi uze hostela Fostora's?
Ukuphendula nama nginalwazi ngiyafisa ukuthola impendulo yakho ukuthi kwakuyini enibizelwe yona.
To answer you, I have no knowledge. It is also my wish to know as to what it is that he had called me for.
Now, I'm going at Syria team, like I said, at Syria team that is one after the other, paragraph by paragraph. Now, I'm going to touch on paragraph 2 of your statement, in which you say that accused number 2 is your cousin. Is that still your assertion, correct?
Usasho namanje ukuthi umzala wakho noma cousin wakho umsolo wesibili?
Ngicabanga ukuthi uma ngithi cousin ngoba uzalwa kithi uzalo lakithi cousin wami.
When I say that it's my cousin because he is by birth, he is of my family.
Ngike ngachaza mhlambe ngathi uzalwa ugogo wami ongizalayo ugogo wakubo. Should mangithi ugogo wami uMantanzi yena ugogo wakhe makuthena ka yena kokantanzi ngeke ngize ngikuphike lokho.
And also I did mention it that my grandmother is from the Ntanzi family, and if it is that he is disputing that he is from the Ntanzi family, then I wouldn't know.
He doesn't at all dispute that he's an Ntanzi, and in fact he does confirm that your father and his father are cousins.
Akakuphiki ukuthi wakwantanzi kodwa akakushoyo ukuthi ubaba wakho kanye nobaba wakhe ke bawo cousin.
Your comment?
Uthini?
Ukuthi ubaba wami nobaba wakhe ama cousin.
Yes.
Nazi kanjalo na.
That's how I know it as well.
But however, that he does not know your father and he does not know the grandmother that you speak about because he was born in 1990, so the people are too old for him to know.
What does that mean?
Witness is laughing.
No, Mr. How does he know then that his father is his father's cousin?
I'm coming to that, my lord.
No, that makes sense for this court to understand.
Yes, I'm coming to that because he said after your testimony here, that's why he sent me to phone around. That's when he was advised through me that the grandmother he does not know. I learned that from his brother, that is Njabuseli Ntanzi, who will come and verify that in this court, and also Zolitini Ntanzi will say he does not know the grandmother.
Ilokho angifonela thi ke angiyobona laba bakibo wazwile kamagama wabizile laba kwaNtanzi bazoza bazosho ukuthi yena nanje ngoba ehlezi lapha yana ke akamazi ugogo lo wena okhuluma ngaye.
Angazi noma mhlambe uyizwile ubaba uthe ubaba wakhe nobaba wami akazi.
Okay, lapho I don't know whether you heard yourself when you said that his father and my father are cousins, yebo? Ngaqhubeka.
So angazi ukuthi uma ukuthi uyamazi ukuthi ugogo ufike ngonyaka ofile noma ngabe uyandlule Mhlambe mina ngibekile ngenze njani ukuma ukuthi ugogo wafi ngamazi yena ngoba mncane.
Now that the grandmother passed away in a certain year, now what is it that I should now do when he says or alleges that the grandmother passed away when he was young?
Okay. Now, without compromising your security, can you tell us where you grew up? Because there are where you grew up, you didn't grow up with accused number 2 and some of his brothers that I've mentioned, Mjabuliseni and Zweli Ntanzi.
Ngaphandle kokucompromise ke i-security noma i-safety yakho ke ngabe ukhulele kuphi futhi ke la owakhulela khona ke yena uthi umsolo wesibili awukhulanga naye kanye nabafowabo umjabuliseni kanye noZweli.
Mhlambe mawungabuyela nje ngoba ubuthi uzama ukulungisa statement zami ngithe kuyi statement zami abanye babo ngikhule nabo bebancane ngabashiya emakhaya.
Okay.
Ukukhula nabo ngishintshana ngaze ngikhule nomuntu so kodwa ngikhule nabo same area abathi bona so khona babami. Angazi uma ukuthi mhlambe uthi bona ngikhule nabo usho ukuthini ngoba ngiyasho ukuthi ngikhulele nabo ngoba bazobaba sho ukuthi bayazi ukuthi ngikuphi ekhaya nami ngiyazi ukuba kubuphi.
If when I rectified or corrected my statement, I did mention that I grew up with some of them, but left them when they were still young. Not that to say that we grew up for a very long time. And if they then say that they know, or he says that he knows my father, meaning that he knows where it is that I grew up.
Now, before the alleged incident of the 26th of October at Fosloras, did you ever meet accused number 2 before?
Ngaphambi kwalehlakalo saseSloras sange-26 ka-October 2014, ingabe phambi kwalokho, phambi kwaleso sigameko lesi, wahlangana noma wake wahlangana yini naye accused number 2?
Yebo ngangambona.
Yes, I saw him.
Ngasemakhaya.
Back home.
Ngasemakhaya meaning exactly where?
Must he disclose where he lives so that he must be killed? I thought you were considerate. You didn't want him to disclose
let me
his
leave it
whereabouts because of his safety being compromised.
Okay, then the version that I must put to you is that accused number 2 says he's never met you before and he only saw you from last week Thursday when you came to testify at this trial.
Thakakazi uhlangana nawe yena uqale ukubona ngqa esine kwiviki endlule uma uza la enkantolo uzokunikeza ngobufakazi.
And so sorry.
Noma ulahlwa zihlobo kwesinye isikhathi kumele kwamukele.
Even if you are deserted or abandoned by family at times, you need to accept that.
And accused number 2 further denies that he knew or he knows who Gwabini is.
Yakuphika nokuthi uyamazi ukuthi uGwabini ubani. Is a remark how
Ngicela ungaphawula.
May I not comment because I'm thinking of family.
And on behalf of accused number 1 and 2, the suggestion is that, sorry my lord, I see accused number 1 is raising his hand. May I approach my lord?
Yes.
Thank you, my lord. I'm indebted. The bottom line is this. Your answer is that you are saying that when family... repeat that for me. Sorry, that answer that. Maula or something to that effect.
Can I almost attempt this?
Yes.
Okay. Uthi ucela uphinde kunaloko okushilo ke noma ulahlwa umndeni kumele ukwamukela.
Oh, yes, yes. Okay. The bottom line is this, and I'm not going to belabor that point. Accused number 2 says he hasn't met you, he hasn't grown up with you. In fact, he's 4 years younger than you as well.
Uthi akakaze ahlangana nawe, akakhulanga nawe, futhi ke mncane yena ngeminyaka ewu4 kuwena.
Ngicabanga uma withdraw mhlambe khona Friday ukuthi ubuze ngokuthi sihlobana kanjani sikhulelephi kanjani ngicabanga ukuthi kube wena owithdraw lokho. Angazi noma ubuyela kulokho ngize ngabonga ngathi ngiyabonga mawukuthi accuse number 1 uyakwemukela lokho.
When you said on Friday that you were withdrawing the question that you were having as to where we grew up, I even said thank you with regards to that, and I also thought or accepted that accused number 1 also welcomed that.
So sorry, did I say accused number 1 or 2?
Uthi yena ukhuluma number 2.
Oh, ukhuluma ngo-accused number 2.
Yes.
Yes, baby bancane kimi.
Yes, they were young, they are younger than me.
Okay. Now, on behalf of accused number 1 and 2, in paragraph 2 of your statement, when you said Gwabeni told you that his homeboys were coming, accused number 1 and 2, they were not part of the group of the homeboys that you refer to in paragraph 2.
Just a moment. Gwabeni told me. Oh yeah. Uthi ke number 1 no number 2 yena ke babengababona babengasiyona ke ingxenye yalabo ama homeboys la uGwabeni wayekutshela ngawo ukuthi nabo bayeza. Bathi bona ke abekho la kulama homeboys okwakhulunywa ngawo la.
Vele umakhelwane ba mhlambe mayithi ama homeboys amanye engabe bala mhlambe accuse number 3 4 5 bona mhlambe engathi umakhelwane bakho or umuzwa kaSibiya kwangadinga uthathi ama homeboys.
Yes, indeed. Maybe he was also referring to my neighbors because 3 4 5 umakhelwane.
Umakhelwane umuzi.
Okay.
Should mighty homeboys wayibala bonke abantu basendawo.
All right. When you refer to homeboys, he was now referring to all those that are from the village or are from the area. And then wasuthi uma wayezothi umuzi uma kwenzenjani?
Mhlawumbe kuba wayezothi mayikhuluma ethi ufuna ukubona umuzi wayevele akubeke straight athi umuzi ufuna ukubona.
If it was that Muzi is the one that wanted to see me, then he would have just said it direct that Muzi wants to see you.
Okay, let's move on to paragraph 3 of your written statement, typed out statement. I'm sorry, let me not say written, typed out statement. Now you state in paragraph 3 that upon arrival at Gwabeni's place, you found him and other boys from Nongoma who you know because you all grew up with from the same area. Who are you referring to as the boys that you grew up in the same area?
Mase ngifika ke khona noma sengifica kwaGwameni kanye ke nabanye ke ababuya kwaNongoma.
Yeah, no.
Uthi lana ke ukhuluma ngobani la ukhuluma ngabo lapho?
Mangicabanga manguphendula nje ngithe abantu ababelapha endlini kwangayena umuntu oyedwa kwangayena futhi umuzi noma afika o abathathu laba bangapha kodwa kwakukhona abangasekhaya including usinakho mawubheka ngekambala ukuthi kwakukhona usinakho baningi futhi ababekhona kodwa bengathanda ukuveza amagama abantu ababekhona kungenasidingo.
When I mentioned it or when I said this, that I did say that it was not only one person who was there. There were a lot of people. It was not Muzi, it was not only Mafiga or the other three gentlemen, but there were others as well. I also did not want to make mention of names without any reason for me to do that. There were also the likes of Sinako and others. There were many from back home.
And you further state that some of the boys you haven't seen for decades. What do you mean that you haven't seen the boys for decades?
Kunalana ukhulumayo ukuthi ke abanye iminyaka decades ngingasababoni. Usho ukuthini?
Njoba ngisho ukuthi mangihamba bengihamba mhlawumbe omunye ngamboni, omunye ngiyobuye sekhulile, omunye ngiyobuye ngamtholanga kulokho mangifikile mhlawumbe angikumbona. So kuyoba iminyaka ukuthi omunye ngisamkhumbula engakanani kodwa lo yakubani. Ingakho kwabe ayingenze le introduction yawo.
As I've said or mentioned that I would leave the others maybe young, I would come back, the others would have grown. When I come back, the others are no longer there, or are not staying there, or I don't see the other one. Hence, Gwabeni then had to do the introduction as to who is who.
Now, from that pertaining to accused number 1 and 2, who have you not seen for decades?
Ngokumayela ke no number 1 no number 2 ubani kubona ubunama decades ungasamboni.
No Muzi ngisho ukuthi bengamboni.
I would say Muzi I haven't seen
5 years, 7 years, 8 years.
Maybe 5, 7, 8 years.
Ngibone sengibona nje futhi sela igole sekhulile. Ngingazi nayo sesegole.
I saw him here in Gauteng and he was grown up. I also didn't know that he was here in Gauteng.
A decade in my knowledge is 10 years and above. It's not 7 years.
Are we going to split hairs, please? Mr. Are we going to split hairs?
Am I, my lord?
Are we going to split hairs? 10 years, 5 years, 7 years? The witness is conveying the concept that is years, decades. That's how people talk. I haven't seen you for decades.
Yeah.
Maybe he's even shortening that with 1 hour. Are we going to now say?
Then you proceed in paragraph 3 to state further that Gwabini introduced you to Carlos and in brackets is Gada and his real name you say it's Mutobisi Ngube Mafika Bongani Ntanzi Mtokozisi Mapisa. You see that?
Yeah, I see that.
Ngiyakubona lokho.
Now, why would it be necessary for Gwabini to introduce you to Bongani because he's your cousin?
Manje ke kwakuyini isidingo sokuthi aze akuintroduce ke nakubongani ngoba yena cousin wakhe.
Njengoba bekungishilo ngathi bengahlali nabo. Mhlawumbe amunye bengasalikhumbula igama lakhe bese ngikhumbuza ukuthi lo nombe yamkhumbula kwakubani and khona amagama besibizana ngawo mhlawumbe bebengazi ngalo. Nami nje lelo abalibiza la icourt bayaqabuka ukulazi bebazi ukuthi nguzo.
As I already said that others I haven't seen for a very long time. And he would then say or remind me, do you remember who this is? And there are names that would refer to each other by. Even the name that are being referred to here in court, that came as a surprise to them.
And you proceed further by stating that you did not need to be introduced to, and I'll state them by accused number 1 and 3, but there you give the names because you are used to them and you see them often. You see that part where you say
1 and
3, that will be
paragraph 3.
Muzisi Bia and Carlos Ntubisisi Gadla.
Lana, we are sure. Yes, the witness acknowledges.
So you say those 1 and 3, you saw them often. How often did you see them and where did you see them?
Uthi buvamise ukubabona ke 1 and 3. Buvamise ukubabona kuphi?
Njengo qale ngoba accuse number 1
uthi 1 and 3.
Yes.
Okay, 1 and 3. Umuzi bengimbona ekhaya mangifikile, mhlambe mayedlala sakhula bengimbona lapha.
I would see Muzi back home upon arrival. Maybe if he would be playing there, I would then see him.
Then uCarlos bengimbuza mangifika lapha na uzangikhumbuza ukuthi uyamkhumbula uGadla.
I was asking about
ngakho kubhaliwe lapho ukuthi wakabuthelezi ngoba ngangazi ukuthi ungakabuthelezi.
And then
ngikhumbuza.
He was reminding me about Gadla because I asked about him upon my arrival there. Hence it is, do you remember Gadla or Carlos? Hence it is written there, Buthelezi, because I knew him as a Buthelezi.
Now, accused number 1 still stands by the submission and a suggestion that I put to you on Friday that he only met you here in Tembisa when you were in the company of Gwabini for the first time.
Sorry. Are you aware what you're saying? He only met you in Tembisa.
That's
well, in other words, he places himself in the area.
Let me take proper.
I want to be fair to you. Because I recall that he was nowhere near the alleged scene of the alleged murder of Senzo.
My lord, we are not talking about
Okay, go.
This is Tembisa, not Fostoras. That's the submission that he said I must put to
So
you.
he was in Tembisa.
He was in Tembisa.
Okay,
The
fine,
incident happened in Vosloorus.
Okay.
uthi uqala ukungibona eThembisa.
Thembisa uhamba noGwabini.
Yes.
No, ngeke ngiphikise kodwa mina ngithi nganginaye Vosloorus ngalelilanga yimi engamshiya futhi.
I wouldn't dispute what he's saying, but I was with him in Vosloorus and I am the one who dropped him.
And on that aspect, he says, in 2013, before he moved back home in March of 2013, at all times, when he was still residing at the hostel, he was residing at Basutini Hall. He wasn't, Basutini section of the hostel. He didn't stay outside, so there was no need for you to go and drop him somewhere. If that's your
Akushoyo ukuthi ke ngo2013 ngaphambilini kokuthi ahambe kabuyele emakhaya noma abuyele ekhaya ke wayehlala khona ke iBasuthwini hostel sasingekho ke kwakungeke kubekho sidingo ke sokuthi uhambe uyomdropa ngaphandle ngoba wayehlala khona phakathi eBasuthwini hostel.
Sorry, is this hostel in Vosloorus, the Basutini hostel?
Yes, he was staying there up to 2013 March. Then he went home from there, came back in 2015 according to my instructions.
And so he was residing at Basutini hostel?
He was residing at Basutini hostel.
Okay.
Uthi ke uye wahlala ke eBasuthwini hostel kodwa ke wahamba ngoMarch ka2013 ngaphambi kokuthi abuyeke ngo2015 abuyele khona eGoli.
Ngicabanga ukuthi kuyobe kwanele lokho engoshoyo ukuthi ngamdropa umuzi ngalelo langa.
I think that which I've said would be enough, that I dropped Muzi on that day.
And accused number 1 and 2 instruct me and reiterate their denials that they were at Vosloorus at a party hosted by Gwabini on the 26th of October 2014.
Bameleke kuloko abakushoyo ukuthi nje baphikisana ke bona baphika ke bona ukuthi ngazo i26 zika October 2014 babe se hostel eVosloorus kwi-party eyayenziwe uyena uGwabini.
Angeke ngibaphikise mabethi bayakuphika lokho kodwa mina ngoqinisekisayo babe khona futhi ngababona.
I won't dispute if they say that they are denying that, but what I am ascertaining here is that they were there and I saw them.
And ngakusho kwakho lobo ukuthi nami ngiyafisa vele ukuthola impendulo ukuthi ngangiyokwenzani khona babe ngibizelini.
And also on that, I also wish to know as to why was I there? Why did they call me?
Who called you? Are you saying accused number 1 and 2 called you there?
Ngithe ngafonela uGwabini kwe statement sami ndo.
In my statement I said Gwabini called me or contacted me.
Now let's move to paragraph 4 of your statement. Now you testified in evidence in chief that before you drank alcohol, your service pistol was on your person, correct?
Ushilo ke nokuthi ngaphambilini kokuthi uphuzeke utshwala isibhamu sakho somsebenzi sasikuwena.
Yebo.
Yes.
And it is only then when you started partaking of alcohol that you gave the firearm to Gwabini for safekeeping, correct?
Kuzothi ke uma senqala ke noma usuqala ke uphuza ila usithatha khona ke usinika uGwabini. Yes.
And in my questioning of you on Friday, and you'll correct me if I'm wrong, I asked you whether or not you placed that firearm in a bag together with the car keys, and I think your response was that you did not. You handed the firearm as is to Gwabini, correct?
Yebo?
Yes.
Now, if I read to you at paragraph 4 of your statement, at line, because I've already read this paragraph, I'm not going to read the whole of it. At paragraph 4, line 1, 2, 3, 4 towards the end, where there's a Volkswagen Polo and full stop, it says, and I read from there, I quote, I then went outside and removed my vehicle out of his way, and he left, but later came back. I then took my bag out of the vehicle as it contained my firearm. I also put the vehicle key inside the bag. Do you see that?
Yes.
and I gave the bag to Gwabini for safekeeping in his room. He locked the bag inside inside his, the bag inside his bedroom as well as Makosonke's bag. Up to there, I'll close the quotes there. Do you see that?
Yakubona lokho. Yes.
So your viva voce is contrasted by here, because here the firearm was placed in the bag together with the car keys.
Ngokwalokhu ke kuyaphikisa lokho okushilo ke la enkantolo la uthi isibhamu sakho wangasifakile kwibheg ngokwalapha ke lokho kubhalwe lapha isibhamu kanye ke nezikhiya zemoto ezazisesikhwameni.
Uma ungasho ngithe isibhamu sasekimi ngithe mangisikhipha kimi ngasinikeza uGwabini ngokufuthi ukuthi uzosifaka vele ebhegini kodwa ukuzivula kwakhona ngambonisa sona isibhamu ngeke ngimnikeze inkulumo isesakeni ngithi baba le bhegini lesibhamu ngambonisa isibhamu mangisifaka kulapha ngangimbonisa sona kunasi isibhamu.
Oh, so uthi wambonisa wase uyasifaka kuyona ke ibheg.
Mangasifaka ngayi like manje kodwa ngathi mangase ngishila ibheg ngoba ngahlala ngaphakathi isikhathi eside ngesibhamu.
Oh, I gave the bag to him and then the firearm was with me. But then when I gave him the firearm, I then showed him that here is the firearm, because I would not have spoken about something that he couldn't see. I had to show it to him that here is the firearm, and not say that there is a firearm in the bag with him not having seen it.
And in your viva voce evidence, you said later on, when it was time to go to Tops to buy further or more alcohol, you left with 4 other persons. That means 5 persons, yourself plus 4 other persons, correct?
Nithe umane seniya ke kwa Tops nani u5 ninonke emotweni.
Yebo?
Yes.
However, in your written statement, which I read, the last 3 lines starting at, and I quote, I also at some point went out to the shops to buy some alcohol drinks with a certain lady and came back into Gwabeni's house. Close quote, you see that?
Yes, I see it.
How do you explain away that inconsistency?
Lokumehluka ke uchaza kanjani?
Umehluko wala uma ubona lapha kwi statement sami ukuthi ngihambile ngothenga nabo utshwala Tops and mangibuya ngichazile futhi ngeke ngaphuma nomunye intombazane owayithenga khona la eduzane. Shoot indlela kubeye ngayo ukuthi with another lady or what, but it's a straightforward ukuthi ngiphume namadoda saye Tops sabuye Tops samba ngeuno masibuye Tops ngeke ngaphuma nomunye intombazane wacela ukuthi ngithenga le drink.
I think maybe it's the manner in which it is put here, but I did go to Tops with the gentleman. We came back, and then there's a lady that just wanted to go nearby. They requested me to buy her a drink, and I did go out with that lady.
Now I'll put it to you, and I'm not going to believe at that point that this one of you going out with a lady to buy alcohol, it's a new addition. You didn't mention it in your evidence in chief.
Kushake lokho akusiyona ke into oyikhulumile uma ufakaza la enkantolo. Yebo ikubhaliwe lana kodwa awukushongo la enkantolo.
Mhlambe bengangibuzanga ngakho ukuthi mhlambe ikhona intombazane ngaphuma nayo.
Maybe I wasn't asked about it as to whether was there a lady that I went out with.
Now we come to what you touched upon with the Honorable Court on Friday, which is paragraph 5, and I'll read it and we will touch on that. I'm not going to believe that because you had partially given explanation for the inconsistencies that are there. It says, and I quote, around 9 p.m. on the very same day, I noticed Muzi Sibia, who will be accused number 1, Mafika Sandi Sontanzi, accused number 2, and Ngani Sfisoguche Zunguntuli, who's accused number 5, walking after each other to Gwabeni's bedroom coming from outside. Close quotes, you see that?
Yes, I do. Now,
you explained away Friday that inconsistency to say the person, the latter mentioned person, that is Ngani Sfiso Kutle Zunguntuli, was not supposed to be mentioned on that statement. Rather, the substitution should be made for accused number 3, correct?
Yes, the witness confirms.
And you also testified that as this statement was made in the following manner, and correct me if I'm wrong, that as you were narrating the story from the reference pieces that you have, the notes, let's forget about them because they're not here. You were narrating the story and the Ms. Mokgoatlheng was in front of you typewriting what you narrated at the same time, correct?
Ushilo ukuthi asikhohleke ngawo ama notes ngoba wekho lana ke ukuthi nanjengoba wena ke wawukhuluma lona ke yena kwayehlezi ke lapha ku PC ebhala ke lokhu okushoyo.
Yebo?
Yes.
Perhaps you'll explain to me because it's this ingenious for you to say that, and I'll put it to you because if you are sitting with a typist in front of you typing what comes from your mouth, why would that typist then, if you want to say Mthobisi Gada Ngube, write Ntuli? Because it comes from your mouth. She doesn't stop. She listens to you. She types out what you are saying to her.
Bese kwenzeka kanjani ke uhlezi uyakhuluma lo muntu obhalayo ngithi ubhala lokho kuphuma kuwena uma wena uthi Mthobisi Gadla Mncube kwenzeka kanjani ukuthi yena abhala unkani isifiso uzungu Ntuli?
Advocate down umchazela uma ngibiza bengibabiza ngegama njengala igama engibiza ngalo bengibuza umuzi ngegama but uma itype ngeke eyozi type njengogadla mina bengimbiza ngogadla ukuthi ugadla umuzi umafika kodwa la kukho lokho shuthi igama bengilibiza lelo igama ongelabo amagama abo mina bengiwabiza ngawo so ngenzeka ama item mhlawumbe ethi gadla athi nkane lo it's a mistake amagama oyibona la le enzama ukuyenza ngathi yona inkinga akusiyona inkinga lamagama ilamagama uthama isplaceekile instead of ugadla kungena igama likankani yilokho kuphela inkinga.
It is only the names that is here a problem, or that you want to make as if it's a problem, but it is not a problem, where I would mention them by their names, Muzi, and then instead of Gadla he would then write Nkani, but that is what happened where the names had been confused.
I don't understand, because if that was the case...
Sir, why don't you understand? He's explaining.
I'm trying to understand, Malot.
But he's explaining.
Yes,
Why don't you understand?
I need him to explain.
Okay, fine.
Because my Lord will ask me whether I understand myself. So let me hear from him. You say something about the spacing and the names. I'm not sure whether I'm getting you correctly. Explain that so that I understand it, please.
Spacing and the way.
So now you are saying that
you are referring to spacing and the word.
Okay,
now.
so sorry. You are saying the names as it were written. I don't know. That's why I'm saying.
He is saying the typist confused the name Gadla, for instance, and Nkani. That's what he's saying. Are you saying that, sir?
Correct, my justice.
Please.
Now, let's move on. Let's not belabor this. Now, if you say you took this statement, it was made on the 31st. When was a copy made for you?
Was made on the same day.
Ikopi ngayenzelwa ngalelo langa i-31st sikamei.
And you took the copy home, if I understood your evidence, then when you read it again at home, you realized that there were these inconsistencies, correct?
The witness is nodding in consent.
Yeah,
yes.
And did you then pick up your phone and tell Colonel Ginin that wait before you distribute that statement to the defense attorneys because I've observed discrepancies thereon?
Ingabe usulithatha kucingo lakho ufonela uGinini uthi ngaphambi kokuthi ke leso statement usihambise ke kuba mmeli khona ke amaphutha engwabonile la wakwenza yini lokho
ngenhloso yokuba safe besingadibani now and then sasidibane ngalelo langa ngathatha statement ngihamba naso emva kwalokho ungabonela ama note ngabe memfonela ngabazisa ukuthi no ulapha kunama problem kodwa bebekubizela ukuyoconsulta advocate.
For safety reasons,
for
safety reasons, we didn't meet or we wouldn't meet. But then, when they contacted me, when we had gone or called me to come and consult, I then notified them of the mistakes.
Okay, just and also not to compromise your safety. At the time you made this statement, you were now under the witness protection, correct?
Protection when's the statement?
Witness protection?
No, I wasn't.
Okay. All right, let's now you continue in that paragraph 5 that you observed or noticed. In particular, let me leave the other person because he's represented. You noticed accused number 1 giving Kwabini a .38 special revolver firearm, correct?
uthi ke kubuza ngo number 1 khona la ukhuluma khona ngabantu abanikeza ugadla ibhamu kodwa uzokhuluma ngalo omelo uyena omunye umelo naye uthi wase ubona ke unumber 1 enikeza uGwabini i38 special.
Okay, asiyilungise bengaze bethi uthe ugadla base shothi ubukhuluma ngobani
Accused number 1. Yes, .38 special.
Yes.
Okay. In fact, just on a small aspect that nothing maybe may not turn on it is this. You also testified that as they walk into the room, the three gentlemen that you've testified about, something was faulty with the lights, whatever.
Ukhulumile ke nange light ke eyayinenkinga nkathi ke uthi wababona beyongena ekamereni.
Ngithe mangifika ngaphakathi wacisha ilight uGwabini ngenhloso hayi ukuthi walicishe ngaphezulu manje ngenhloso ukuthi wathi nango baba omncane then kwase kuba nalento ukuthi gqike ngathi kucisha ilight yabo kanti vele ngangiphakathi ngoba ngangibalandela emuva bona babenganokuthanga ukuthi ngiyabalandela kodwa uGwabini wangibona ngoba wathi mabengena ngaphakathi ngangena nabo yabona afika kamnandi nje kusenzeka leyo action.
I said that Gwabini switched off the light because he had said that here's my uncle or here's Ubaba Mngani. They didn't see or they were not aware that I was following them. But Gwabini saw me that I was walking behind them, and upon arrival that uthe yini le wafika usebenzise igama uthi wafika leyo ise on ini
ngithe mayikwafu ngifike ngiwathi mayingena endlini kwabe sekuba khona lokhu ukuthi kungathi kucisha ilight.
Okay, it was as if that when I got into the house or into the room, it was as if the light he was switching it off. Yebo kukhona lokho kushilo ogcineni uthe ngafika lapho ise on leyo
ngabe sayenza bese isenzeka shothi nje lento yayisenzeka ngoba lokho
when I got into the room they were still busy with that they were busy with.
Ngoba wabona ukuthi uGwabini ngeke sakhona ukungivimba ngoba sengingenile ingakho ayizama mhlawumbe ukucisha ilight
because Gwabini then realized that he won't be able to stop me because I was already there, hence he then tried to switch the light.
Okay. Now earlier on Thursday and Friday you testified that, and I use your word, that it was busy in and around that vicinity, that is the common area. Although the room was locked, you could observe it. That door of the room of Gwabini, is it directly facing the kitchen area?
Isicapha lesi sekamera kaGwabini ngabe face direct kitchen.
Yebo mawungena nje uyakwazi ukubona noma ungaqondile straight kanje kodwa nje uyakhona ukubona uyena.
Yes, just upon entering, although it is not directly or straight with it, but slightly you are able to see it.
And your testimony is that you came together with Makosonke at Gwabini's place. Did you then tell him that I've just seen something? I saw Gwabini receiving a firearm from accused number 1.
Ngithe mangiqoqa lapha ku statement sami mhlawumbe awusifunda ngakahle ngithe uMakhosonke akatholakala mase ngihamba yilokho kwangishiya ukuthi ngibe nembuzo ukuthi why ngatholakala mase ngihamba.
Maybe you misread my statement. I did mention that when I was leaving or when I was about to leave, Mokgoatlheng was nowhere to be found, which then made me then to be suspicious as to why is it now, after having witnessed this, that Mokgoatlheng is nowhere to be found.
Now, the instructions from accused number 2, and it pertains also to this paragraph 5, is that you saw him changing hoodies from black to gray.
100%.
He instructs me to tell you that that never happened.
It happened very much so.
Now, let's move on to paragraph 6 of your statement. In fact, this version, I've already put it to you, pertaining to you giving accused number 1 a lift, and his instructions are that he was not there, but if he was staying at the hostel in 2013, he was staying at Basotuli hostel, so I'll leave that one not to repeat myself. Now,
you don't have the 6 here?
You don't have paragraph 6.
No, it's fine.
And you also testified that at some stage, accused number one stood up and announced that the deceased is normal, that is Senzo Meyiwa.
Yebo?
Yes.
Because he was not there, he denies as well that he uttered those words.
Ngoba wayengekho ke lapho uyakuphikeka nalokho ukuthi wakusho.
Ngeke ngimphikele maye ukuthi mhlawumbe kwakuyikhophi yakhe lengangikhuluma lokho.
And then I wouldn't then be able to say anything if the one who said that was a copy of him.
Now let's go to paragraph 8, the morning of, or the day of 28/10/2014, when you now observe a newspaper article with certain sketches and the story that the deceased is normal. You remember that?
Yebo?
Yes.
Now, then, when you saw that and your suspicion is aroused, did you tell anyone, did you report this, that these people that are on this newspaper article, I was with them at the party in Vosloorus on the weekend?
Masukubona ke lokho ngalelela langa ke lange 28 ngabe yini mase nakuvuka insolo ukhona umtshela ukuthi but labantu laba bala ngabazi nganginabo ngepartini eFosloorus.
Noma ngeke ukuthi ngakhona engamtshela ukuthi ngibone ukuthi nokuthi kodwa ngathi mangubona ngakubona kubuyisa emqondweni wami ukuthi yini engiyibonile especially ngokushintsha kamafika kwakhe jacket yikho kwangenza ka notice ukuthi man mabethi begqoka into eblack lo umafika wayithi mayifika lapha ashintsha ijacket yabo.
Although there is no one that I informed or that I told, but when I saw this, but it then I then recalled in my mind, and especially when it was written or mentioned there that the other one was wearing a hoodie, and then it reminded me of Umafiga who had changed a hoodie.
Kodwa ngathi mangibuka lo we dread ulivulekile imqondo nami kwangekhona ukuthi mhlawumbe sekumele ngihambe ngiyobuza ukuthi ubani ngangenzanga investigation ngabe sengithule futhi ngangabazondanga ukuthi sengaze ngiyabasukela ngentension.
And also when I saw the one with the dreadlocks and his dreadlocks were loose, I didn't now go out to make my investigations. I wasn't hating them, or I didn't hate them now for me to be able to go and investigate.
Let's move on to paragraph 9 of your statement. You testified that you then contacted for the first time General Leshabane. When did you do that, if you recall?
Uma kuukuthi sakhumbula ke wamfonela nini uGeneral Leshabane?
Mangicabanga kwaku 2018 yophela or 2019 uqala kodwa nje.
If I remember well, towards the end of 2018, beginning 2019.
And do you recall exactly the detailed information that you told General Leshabane at the time about your knowledge of the Senzo Meyiwa murder case?
Ngabe usakhumbula ukuthi yini kahle kahle owayitshela uGeneral Leshabane mayelana nolwazi lwakho owawunalo ngokushona kwaSenzo Meyiwa?
Ngamtshela ukuthi nginezinsolo zokuthi abantu abenza lokho nginolwazi labo.
I told him that I have suspicions that the people who did that, I know them, or I have knowledge of.
And obviously you provided the names of those people to the general.
Waseke uGeneral umnikeza amagama alabo bantu labo.
Ngoba nami ngangakazi ukuthi babe bangaki kungobani ngamnikeza amagama alabe ngangazi bakhona.
Because at the time I didn't have information as to how many they were, I gave them the names of those. Okay, I gave him the names of those that I knew.
And the two will be? The two names that you gave will be who and who?
The first two names will be Muzi and Mafiga.
And let's move on to now when General Leshabane says he needs photos or pictures of the people that you are talking about. Your testimony is that which pictures did you give him? of which suspect that you suspected did you give him?
Iziphi ithombe noma abapha abasolwa owanikeza ngezithombe zabo ku General Lishabane nkathi esecela ke ithombe?
Masilungise la Nkunzi. Angamnikezanga ngambonisa zona. Isithombe sika Muzi noma Afrika.
Let's correct this. I didn't give him the pictures. I showed him the pictures of Muzi and Mafika.
From where did you show him the pictures? From which device or article did you show him the pictures?
Ngangifake efonini yami.
I had put those or placed those pictures in my phone.
Had you at all times before then had those pictures of accused that you gave to Lishabane, or did you have to source them somewhere else?
Ngaba ithombe ayithola ndaweni ithize noma ithombe owawuhlezi unazo?
Ngayithola efonini kaGwabini.
From Gwabini's phone.
Now you were shown Exhibit S, and for the sake of completeness, I'm going to ask for it to be shown so that you can show me the pictures that you showed to General Lishabane. Will they be on that exhibit?
No, azikho lapha.
They are no, they are not there.
And do you know if they are on any exhibit that you are aware of? Because I see at the end of your statement, we'll come to there, I see you refer to photo albums from which you identified the suspects. If you go to the last paragraph, yes.
Yeah.
The photo album that you referred to, that you identified accused number one, what photo album will that be?
Yiphi le photo album le othi number 1 wambona kuyona? Ngokwala.
Ngokwalana ngicabanga ukuthi ngibona inamba lapho 10 to 17 22 to 24 mawangibonisa leso sithombe ngakwazi ukuphendula.
If you were to show me the picture, I'll be able to refer you, because here I only see numbers.
Let's defer this question because my learned colleague Mr. Sibanda will have to arrange them for us so that we can take them in a structured manner. So we'll do it at the end of your statement because I'm going through it at Syria team.
Sorry, you never pursued this question on the last cross-examination about the photos. You never pursued
no,
it.
I never did, my lord. Now let's go to the one that I know that you've corrected it, but I want to put certain versions to you about it. That will be Exhibit S and photo or page 47. And my lord, perhaps while he's still browsing, let me take a quick one from accused number 2. Thank you, my lord. I mean, that's it. Now, if you look at that photo 47, and I'm going to be frank and honest with you, I acknowledge that you have corrected that it's not accused number 2 that's depicted there on. So let's be agreed on that one. However, at the beginning of investigations, accused number 2 instructed me that this photo, the police officers that arrested him in Rustenburg at phase 2, Rustenburg, where he resided in 2020, they came with this photo, and when they questioned him, they produced this photo and insisted that he is the person that is depicted on that picture.
Ngiyazi ke ukuthi ke ulungisile wathi cha wenze iphutha akusiyena loya kodwa ke uthi inkathi eboshwa ephase 2 eRustenburg amaphoyisa ambopha aletha lesi sithombe lesi athi uyena loya uyena lo okulesi sithombe.
Ngiyaxolisa benga investigate le case.
My apologies, I did not investigate the case.
Maybe umbuzo loyo ngaphendula umuntu obe investigator in case.
Maybe that question can be best answered by the person who investigated the case. Okay.
And just to finish it off, like you are saying, don't comment if you don't want to comment, but I want to place it on record that the very same photo, accused number 2 was beaten up by the said police officers to admit that that is him.
Ukuqadelela nje kuwena ke uma ufuna ukuphawula kulokho noma ungafunike kodwa ke uthi lesi sithombe lesi washaywa ke amaphoyisa ukuthi ethi akavume ukuthi uyena loya.
Ngizokhomenta ngithini ngoba bengekho futhi bengazothi baphenya nami bafika naso ke lesithombe sebeze kimi.
What will my comment be, because I wasn't investigating, I wasn't there. They also brought the same picture to me or came with the same picture to me.
Who is they? Who brought that picture to you, and what did they say pertaining to that picture?
Obani labo abezana lesi sithombe kuwena futhi bathini ngaso lesi sithombe?
Investigating officer.
Investigating officer?
And did they say anything in particular about that photo, the two gentlemen and a part of body appearing, in particular about the person in the cap? What did they say about you, about that person?
Abangitshelanga ukuthi obani nami bangibuza ukuthi obani laba kodwa bangibonisa sona nje leso sithombe.
I didn't ask who they were. They also didn't tell me who they were. They just showed me the picture.
And with respect to, still on that paragraph, you testified that when you confronted accused number 1, and correct me if I'm wrong, about his involvement in the murder of Senzo Meiwa, he denied that, but he implicated, or was it the general telling you that? So that's why I'm saying, you clarify for me that someone implicated accused number 1's uncle, Spiva Sibia. Who was that person? If you can clarify for me, I'm not sure.
Ubani lo owakhuluma Spiva. Uthi khona umuntu owa implicated noma owa to Spiva le gama.
Yeah, last paragraph. He told me that most disputed the information, but he implicated his uncle, who is well known to the general. I know that Moses' uncle was known as Boshe. I think General mangikhuluma naye wangitshela ukuthi kunomunye amaziyo wakakubo akutshelwa kuye ukuthi usemateksini somewhere lapha.
I think that's what the general informed me, that there's someone that he knows. That information, the general said that it came from him. The witness is pointing towards the direction of the accused, that there was someone from his family related to them in the taxi industry.
And according to your evidence in chief, Spiva Butlebuthelezi died. Do you know when he died?
Ushilo ukuthi washona uSpiva, uyazi ukuthi washona nini?
Noma ngazi ushona nini kodwa ngezwa.
Although I don't know when exactly, but I heard.
Now, accused number 1 will testify and say that, deny that he implicated his uncle in the murder of the deceased Senzo Meiwa.
Uzophika ke lokho uthi yena kazange nje athi ke ubaba mncane noma uncle wakhe ke waye involved ekulaweni kwakhe uSenzo Meiwa. Kaza kusho yena lokho.
Noma ngathiwa akakushongo wayengakukhulumi nama ngithi wayekhuluma nomunye.
Even if it said that he never said it, he wasn't telling it, he wasn't saying it to me, he was saying it to someone else. He has never said that to me.
Now, at paragraph 11 of your statement, and it pertains to your testimony that there were discussions between you and accused number 1 regarding the Senzo Mewa case at the wedding of your sisters in August 2019, correct?
Kushilo ke ukuthi ngo-August uMagano ke usisi wakho?
Yebo.
Yes.
Now, did you report to anyone in August 2019 that you had these discussions with accused number 1 pertaining to this case?
Mhlambe umuntu njani?
Maybe someone like
Police or anyone or girlfriend or boy.
So you are a police officer. If somebody talks about criminality, you report it to the police. Who else do you report it to?
I was already reporting to the general.
beseng reporter vele ku general.
Uyazizwa bafo.
Are you listening to yourself?
Sir,
I'm sorry kusho kanjalo. I will
Sorry
withdraw
to say
that.
that I withdraw that. so-
let's maintain the Quran. Let's not stoop that low. Now, accused number 1 denies that as well, that he has never attended a wedding of your sisters, nor did he make the utterances that you attribute to him.
Uyakufika ke ukuthi akakazi nje ayeke emshadweni kasisi wakho nokuthi washo lokhu wena othi wakusho.
Wayekhona emshadweni,
He was there at the wedding.
wakhuluma nami futhi.
He spoke to me as well.
My Lord, I see we are closer to the long adjournment. I hear Mr. Jonas is breathing a sigh of relief. Can we now take a longer adjournment, my Lord? We'll resume
What's the
at
time?
2.
Mr. Baloyi, what's the time?
It's 1 o'clock now, my lord.
1?
Just a minute before.
Oh, okay. 2 o'clock then.
So we are ngo-2. Isibani ke esapho leso.